Hi, welcome back to AdCast. I'm Carl Vervisch, and I'm here with my lovely co-host.
Hi, I'm Cris Vatalaro.
Tonight we're here with Tom Steele. Tom, tell us a bit about yourself. What do you do?
I'm a lawyer here in Tampa. I've practiced law for 35 years. I have a law firm that specializes in unfair competition, which necessarily brings us into intellectual property concepts that I think you want to talk about tonight.
Absolutely.
Yes.
Us as young professionals and people in the advertising and media industries as a whole definitely have a concern about intellectual property. What is it and how can we defend it? So Tom, I guess the first question would be, what is intellectual property?
Well, there are a lot of different ways to look at it. The traditional sort of splits, if you will, or definitions. You have a trade secret, and a trade secret is something that's kept confidential, and you keep it inside your company. You can have a patent where you disclose it to the United States government in return for a monopoly for a number of years. You can have a trademark or a service mark that identifies your goods or services, and you register that with the federal government if you want. And you can have a copyright. And a copyright simply gives you the right to reproduce whatever it is that you've made. It's guaranteed by the United States Constitution, and so it's regulated by the Constitution and the United States Congress, and you register it with the Library of Congress. Florida is also an interesting state because in Florida you can protect an idea. Very few states recognize an idea as being protectable, and in Florida you have to show that it has novelty, and that's a pretty difficult test to meet. You also have what's called a right of publicity, so that if, for example, the classic example was some guys went out fishing on the East Coast, and when their boat went down, they climbed inside their igloo containers, the ice boxes, and the pictures were taken of them floating around in the Atlantic in their ice boxes. So they sued, saying that under a particular Florida statute, their names and their likenesses, their pictures, couldn't be used for a commercial purpose without them. And so in that case, their intellectual property was their appearance, their names, their look, if you will, because it made it look like they were endorsing.
So in that case, did that end in their favor?
I think it was settled favorably for them.
Okay.
Most of those cases are settled. What we're seeing is more cases that involve trade secrets, because in trade secrets, you don't have to disclose to anybody what your secret is. You just simply keep it quiet, and there's no time limit on it. So as long as you keep it confidential, it's yours forever. And so we get a lot of cases where people are accused of stealing trade secrets, and those cases are definitely on the upswing. And we generally represent the alleged bad guy because
the thief, if you will.
Well,
The alleged thief.
the borrower, shall we
Borrowers.
say, because a lot of the old defenses that, somebody stole a customer list, one of the defenses is that a trade secret can't be publicly available, readily available to the public. Well, to anticipate one of your questions a little later about how the internet has affected intellectual property,
Sure.
I went to a company called R.H. Donnelly, and I bought the exact same list for $269. So we won the case for $500.
So if somebody's out there came to you with a situation where they have, say for instance a logo, and they want to make sure that that isn't infringed upon. I know that's a big issue with creatives in our industry, especially freelancers. What are the steps that need to be taken at that point?
Well, one of the first things you need to do is to determine that your logo is in fact unique. And so what you do is you go to a company called Thompson & Thompson. And Thompson & Thompson will do a search of all the records in the Patent and Trademark Office, all the records in phone books, all the records in other publicly available lists. And if they come up with anything similar, then they'll tell you about it. Then you have to go through and analyze each one and figure out if it's owned by IBM, then you know you're in for a fight.
Yeah.
If it's
Of
owned by
course.
mom and pop in Macon, Georgia, maybe you can sneak up there and buy their rights for a couple $1,000s,
I
and
see.
then it's yours.
So if someone was to choose to go through with trying to obtain a copyright, what is the process for that?
Very
And
simple.
Once that's
Very simple. You can also have a Thompson & Thompson search of a design, a word, anything that you want copyrighted, and you simply, and understand that a copyright, since it's governed by the United States Constitution, there's legislation, and so the copyright object is called a work, whether it's a musical composition, a computer game, a photograph, whatever. And that work, simply by sending it to the Library of Congress, you can secure a copyright in it. End of story. The tricky thing is you can't file a copyright infringement case unless your work is registered. So you have to go through that hoop of having it registered in the United States Congress, but that's cheap.
yeah.
A couple $100.
It's a lot better than having to go through all the court fees and if you go through a lawsuit.
Sure.
Yeah.
Absolutely.
And the thing is, sort of the frontier, if you will, today is, just like people are trying to patent different kind of life forms, plants, things like that, a lot of people are trying to copyright things that in the past couldn't be copyrighted. If it has copyrightable material, then they'll try to copyright it. So the fact that you have a copyright is just the beginning of the effort to protect it. Had a woman who had a particular design on a t-shirt. Well, somebody infringed it in Atlanta, Georgia. She had to track them down in Atlanta, Georgia, had to sue them in Atlanta, but the copyright statute gave her pretty good damages and attorney's fees. So, it's a challenge. I mean, you have to understand that whatever your rights are, they're worth only as much as you're willing to pay to enforce them, because the government won't enforce any of your rights.
Wow.
Now, is there a website maybe that we'd be able to reference?
Well, in about 6 months, you can access our website.
Oh, okay.
Because I think what we're trying to do is to put a lot of information on the site for free, because I think we have to give a lot of people stuff for free to be able to draw them in as regular clients.
I see. Do you guys have a website now?
We do.
And where is
It's
that
called
located?
steellawgroup.com.
And that's Steele, Steele.
L-E, that's right. And right now we're focusing on non-compete agreements and things like that, and move on to trade secrets, and then we're going to move on to trademarks, and then to copyrights.
Okay, so you
Wow.
guys have a large gamut within that range of law.
Yeah, and the thing is, the law changes pretty rapidly in
Yeah.
this area too.
So you need to be with someone that's really keeping up to speed on it, like it sounds like you guys are.
Well, I have a woman who works with me who is an industrial engineer, and her responsibility is to keep track of changes in. We don't do any patent work, but she stays with trademarks and copyrights.
Wow. Well, that's great. Thanks very much for helping us out a little to
Delighted to be
get
here.
our feet in the water of copyright law.
Intellectual property is the growing area, and I think that there are going to end up being 30 different law firms in the greater Tampa area that'll deal with it. It's a huge growth industry, because the more guys like you who are in business, you're going to need more people like us.
Absolutely.
And the last point I wanted to make, we talked about before the show, is you can buy insurance. And I think it's very important that anybody who's in a creative business talk to their insurance agent and try to buy insurance to make sure if they infringe somebody, they can go hire a lawyer cheaply.